Ladies and gentlemen, there are times when the mediation process will absolutely fail you. Sometimes mediation, if not all of the time, is court-ordered, and that means you are obligated to go to mediation. Well, mediation is voluntary and mediation is consensual to the extent that once you've attended, once you've said, here I am, my name is Jane Doe, my name is John Smith, I've done my part. Once you've done that and the mediator has read their instructions, you could say the magic I word, impasse. And then the entire process is essentially done. The entire process can be over. You can turn off your camera, you can press leave meeting. Most mediations are done virtually, and you're done. That's it, period. End of story. However, mediation is voluntary in the sense that once you've attended, you can participate for as long as the process goes on. It could be 12 hours or 2 days without a resolution. It could be 45 minutes, and you leave with all issues resolved. Every mediation, like every divorce case, every paternity case, is unique. Every mediation is completely different, and you have to treat it as such. Okay, so the pitfalls of mediation can be thus. If you have a mediator that is either not paying attention or too intrusive or even too dispassionate, your mediation might fail. Your mediation might fail because there's an absence of effort, an absence of awareness, or even potentially an infringement on the rules of mediation. Mediation, from the mediator's perspective, is supposed to be the mediator gives you their instructions. They are neutral. They are impartial. They have no conflict of interest. They have no dog in this fight, as it were. The mediator's role is to facilitate an agreement, not to guarantee an agreement. A mediator is not a judge. Even if a mediator used to be a judge, in the mediation context, they are not currently presiding over your case. The likelihood is you will see the mediator once, period, ever, finito, end of story. Nothing further, nothing to see here. Here's my mediator's report. Agreement, partial agreement, non-agreement. That is the job and the role of the mediator. Well, sometimes the mediator, in a good way, will overstep their bounds, specifically attorney mediators, and if both attorneys are okay with it and the clients are okay with it, the mediator might interject him or herself into the process a little more than usually might be the case. However, this can be a problem. And when can it be a problem? This can be a problem when the mediator is going too far. If I give my client advice, here's what I believe alimony would be under these circumstances, based upon what we know now at the halfway point of a case. We have the mandatory disclosures. There might be some more discovery to do. Maybe a request for production of documents is forthcoming. Maybe we need to do a deposition. But based on what we know now, with the facts before us, we have enough to make some predictions and some reasonable estimates as to what alimony should be under these circumstances. And the statute tells us the length of time for which alimony might be appropriate. Well, okay, we can advise our clients. If the mediator says, oh, have you thought about it this way? Or, oh, I know you heard what your attorney said, but maybe you should consider what the judge is going to say. Have you heard that the attorney in the other room doesn't think that's appropriate? The attorney in the other room thinks X, Y, and Z. Hang on now. That is not the role of a mediator. And respectfully, no matter how experienced a mediator is, the family law mediation is supposed to be with an impartial mediator, not a mediator that tells you that your counsel's advice sucks, or that tells the other party that their counsel's advice is not applicable, is not appropriate, is not good advice. The mediator is not supposed to contradict the advice of your counselor, and the mediator is not supposed to get in between you and your counsel and drive a wedge. But this does happen often. If a mediator believes that one party is correct and the other party is wrong, or applies their own legal training, if they have any at all, which is not always a guarantee, if the mediator applies their legal training to inform them as to how they should inform you, the client, in defiance of your attorney's advice, your attorney who's been on your case since the beginning and knows everything about it, has seen the pay stubs, has seen the affidavits, has seen the retirement statements, the insurance benefit statements, has done child support calculations, has created an equitable distribution worksheet, and has researched case law and has already been negotiating your case. If the mediator, having been on your case for 5 minutes, would like to contradict all of that and interject himself into the discussion in a way which is not impartial, in a way which is biased, I believe that creates an inherent conflict of interest and poisons a mediation and can lead to an impasse which may cause your case to move forward to depositions, further discovery, and possibly a trial. This is why we must take mediation seriously and choose the correct mediator to the extent possible for your individual case. And this may be why the attorneys sometimes fight over who the mediator is going to be, because we all have a perception of this mediator might really resolve this case. Or maybe this mediator will resolve this one aspect of the case. Or maybe, even if you're thinking in a sinister fashion, the other side doesn't want to resolve the case and therefore they wanted to choose this specific mediator because the case should move forward to litigation. Totally okay if that is their perspective and their client is consenting to that, then that is their strategy, that is their technique, that is what will happen. But I would like to suggest to you that mediation, I've said it before, is a golden opportunity. And to think that a third party who's supposed to be neutral, unbiased, impartial, have no ruling authority, and have no conflict of interest, if that person makes themselves the center of the attention, they've just turned your mediation into a near failure in a three-ring circus for their own benefit, which could very well harm you financially. So consider very carefully before you mediate who your mediator is going to be, what their credentials are, and how your counsel feels about that specific mediator and their role in the process.